This is your guide to book publishing. Everything you want to know but didn't know what to ask with your host, Dr. Judith Briles. On the show today, you'll find out where book publishing is going and how to take advantage of it. How to identify and avoid publishing predators. What opportunities are emerging as the book trade evolves in new forms. How to avoid losing money and much, much more. Join us now as a variety of publishing pros will deliver insights and strategies to take the author to the next level of publishing. It's your guide to book publishing. Everything you want to know but didn't know what to ask. Brought to you by AuthorU and the Book Shepherd. And now, here's your host, Dr. Judith Briles.
Well, here we are already in the second month of the year, which is stunning to me. I've just come back from the fabulous Publishing at Sea cruise that we played with 37 awesome authors, strategies, marketing, brainstorming, taking them to a new direction that they haven't even thought about, and also regrouping and looking at some of the things they should have been thinking about. So this is the perfect show. With me is Julie Bernard, one of my favorite combo biz attorneys, as well as intellectual property. And one of the challenges is that authors just don't think that this is a business. Too many still don't. Although I believe it's a trend coming into 2018 that they're getting it. At least certainly the ones that I work with as the book shepherd. And so it really, there's things that mistakes that just seem to keep happening, whether it deals with copyrights or should I think about trademarking or when do I, file with the Library of Congress or, do I enter into an agreement with someone to help me maybe ghost it or co-write it or fill in the blank? How do I cover myself? So Julie's going to be playing with us during this hour and looking at a lot of these issues and dig into it. So Julie, welcome to AuthorU-Your Guide to Book Publishing.
Thanks for having me, Judith.
All right, so I'm just going to throw it out to you. I mean, you work with business people all the time. You also work with authors, and you're also getting into other things that are involved in just the whole intellectual property realm. But is there some commonality in some of the mistakes that are consistent that you see?
Well, I think the number one mistake I see is exactly what you just referred to, which is creatives, and that's really what I call inventors and authors and people who are in the creative part of a business to create a brand, don't think about their intellectual property as a business. They may, but they don't take it as seriously as they would an accounting of a business or the rental lease of their building. And so one of the big mistakes that I run into is after the fact, after all of the trademarks or copyrights or the book has been written or you had someone illustrate your book, all of these things have already happened before someone actually pays attention to them. And I think that's a really that's way up there. I see it all the time. And a lot of times what happens is, I'm going to call it Google Academy. Someone runs into a problem and they go to Google Academy for a week and they think that they can solve it. And sometimes they've made that problem worse. So they're not necessarily problems that have to be solved, but they're issues that I believe you should preemptively think about. You should proactively think about all of your IP, how to create an IP portfolio. How are those intangible creations going to benefit you? How can you take them from being assets, right? An invention, an expression from an artist, a book, a brand name, and turn them into something that's legally protected that you can enforce. And that's when you create an IP portfolio.
So tell me more about, I haven't heard anyone use that phrase, Julie, an IP portfolio.
So intellectual property, that is an umbrella term that refers to those intangible creations, right? And they can be protected by copyrights, trademarks, patents. You can keep something as a trade secret. You can also have contracts to protect them. So intellectual property, an IP portfolio is when you put together a package of the intellectual property for your business. Now, your business could be that you're an author and you're writing and self-publishing or working with a publisher, or your business could be that you're selling widgets and you have logos and brand names and, taglines, right? There's taglines that are worth significant values because we all recognize them. They're big, let's say, athletic companies, Those are assets, and so you put them into what I call a portfolio. You could make it a file on your computer to track them or whatever. But
Sure.
What happens is you've created a bundle then of rights and assets that is valuable to you, or if you have an exit strategy for your business, it's valuable to the potential buyer of the business.
So that would go in there. Anything that would, we're talking about, king here, anything that could bring possibly cash at a future buyout or evaluation, or if you brought in a partner even. You have to have an idea of what's on the table. And you're right. Just don't think about this at all.
Well, and I think that it's not unusual. It's the number one thing that I talk about. Someone will call me with a simple question and we'll start talking and I'll say, do you know what your IP assets are? No, of course not, because I haven't thought about it, but that's easy. We can talk about it. And then, do you have any IP rights that protect those assets, right? So what are the protections that you've got in place? You may have IP assets. You may actually have an invention or a book or some artwork, but it may not be protected in a way that makes it valuable. So you have to combine assets and rights and create that portfolio.
So when you talk about protecting, it's not just trademark protecting. That can get costly if you try to trademark everything in the world, or maybe I'm wrong.
Well, so here's the thing. Everyone I know says, oh my gosh, intellectual property is so expensive. And it is. Anytime you are trying to obtain rights, so you're trying to carve out a piece of the universe for yourself, there are fees that go along with it and expenses. But when you balance that, when you do a basic business risk analysis, right, cost-benefit analysis, if I spend X number of dollars, what's the value to me? I would suggest to most people that the benefit is much greater than the cost. But it is costly to file and, create a trademark portfolio. It's not costly to file a copyright application, but copyright infringement, protecting and enforcing your copyrights when somebody wants to make a movie using your book, that can be very costly, right? So the way to preemptively assess those things for me is to set them out. Let's put them out. Let's figure out what we need to do. Let's look at how they can be protected and what kind of contracts do you have to have in place, or what kind of permissions do you have to have in place? What kind of writings do you have to have in place to make sure that you've created that picket fence around your intellectual property?
Oh, I love the image. What's the picket fence? Yeah. So I think that's right, and we don't think of it. So it's very simple to think I've got a book. Okay, so that's an asset, but you've got all this other stuff, though, that goes together with the book or the future books or the spin-off products or the online courses or fill in the blank. All of those are assets.
Exactly. That's true. And they should all be considered individually. And then, you can come up with a plan. How are we going to handle this? What are we going to do? What's the budget? And a lot of times when I talk about exit strategies, there are authors and artists that want to get out of the business and retire, and they would like to transfer those assets and rights to a third party. If you don't have your ducks in a row, it's very hard to transfer that as a portfolio, as something that's valuable to a third party.
So that's the
as you go, and I think that you have to have an ongoing process. You have to create procedures where on a regular basis you look at everything. The initial taking a look at everything sometimes can be a bit overwhelming, and I suggest people take one bite out of the apple at a time if they've been working a long time and have a lot of work that they need to look at. But, once you get everything in place, then you can turn it into a process, and you can regularly go through and just do an assessment. What's there? What's new? What do we need to do? Oh, do we need to drop this because we don't need it anymore? It's not part of our brand anymore. Why would we pay a maintenance fee if this trademark's not part of our brand? So there's this ongoing process, and I believe it should be part of most businesses.
You know, you mentioned a magic word here, but I think a lot of times and that's the brand. A lot of times authors don't think of themselves as a brand, or their expertise is a part of the branding process. And that, I mean, we've got about 90 seconds to our first break here, but can you give us a short definition from IP perspective of what a brand is?
Well, a brand is what identifies the source of goods and services, right? So that's really the definition of a trademark, and you use trademarks to brand yourself. So we can talk more about what a trademark is versus what a copyright is and how to use them and what they protect, but really a brand is the identity of the business. And so that identity can be real simple, or it can be very complicated and have multiple assets to it.
Mm-hmm. So, and of course, they always talk about some of the most, expensive, popular, well-known brands would be something like, it could be a Nike or a Coca-Cola. You just hear the words, you instantly know what that all emulates.
If I said just do it, everybody knows who that is, right?
Exactly.
But that is not their sole identity. And the same thing, if you look at tennis shoes, I know we're talking about tennis shoes now, 3 stripes on the side of a tennis shoe is a brand identity. And they're fiercely protected because that is part of their company's identity. But some of those are single trademarks, and some of them are part of a huge portfolio that's all related, or, a section of a portfolio that's directed to that one product. So, it's a brand is really the identity that you're creating for the company, for your business.
Yeah, and it can be complicated. All right, we're going to take a quick break. With us is Julie Bernard, business attorney and intellectual property attorney. I'm Judith Briles, and it's AuthorU, your guide to book publishing.
Is your guide to book publishing. Everything you want to know but didn't know what to ask. With your host, Dr. Judith Briles. And we'll be right back with more great information right after these.
Is there a book in you or another? AuthorU will show you how to create, develop, and publish your book without being hoodwinked. If you already have a book out, you'll find a supportive and brainstorming community that's connected and creative no matter where you live. AuthorU brings in national experts for its book camps and annual author extravaganza held each May. It has regular meetings and delivers webinars for its members on timely topics. Through AuthorU's extensive network, members enjoy exclusive benefits, including significant discounts for a variety of services necessary to publishing. The Resource, its online book publishing news magazine, is content-heavy and it's free. If you want to create a book that has pizzazz, punch, and panache, AuthorU is for you. If you're a hobbyist or a casual author, it's not. Join AuthorU today through its website at AuthorU.org. Follow AuthorU on Twitter at AuthorU and on Facebook at AuthorU, where timely author and publishing tips and articles are posted daily. AuthorU, where the author goes to become seriously successful.
First impressions are everything in the world of book publishing. Whether your book is an ebook, a print version, or both, your book cover needs to pop, sizzle, and sparkle to immediately capture the attention of your audience. And your book's interior needs to be just as dynamic and reflect the professionalism your readers demand. Nick Salinger of NZ Graphics has won numerous national and international book awards for his cover designs and interior layouts. With over 20 years of experience in graphic design, he knows what it takes to create award-winning books and the many promotional pieces that authors need, such as posters, banners, postcards, one-sheets, business cards, logos, and more. Visit ncgraphics.com and see what authors and publishers have to say about their award-winning books and how NZ Graphics can make your book the success it was meant to be. That's nzgraphics.com.
Welcome back to your guide to book publishing. Everything you want to know but didn't know what to ask. If you want to write and publish a book, if you want to be successful as an author, your guide to book publishing, everything you want to know but didn't know what to ask, is for you. Stay tuned and you'll hear about statistics, scenarios, and strategies on what to do now to get you published. So let's get back to the show. And here again is your host, Dr. Judith Briles.
All right, so with me is Julie Bernard, and we're talking about legal stuff, but in a different route, and the whole concept of branding. And so branding could certainly be part of your logo, but what else comes into play here? I mean, we talked about Nike in the phrase, we talked about stripes, goes to one of the shoe people.
Well, what about if someone has a catchphrase, right? What if you have a motivational speaker and they have a catchphrase, and their entire audience starts repeating that catchphrase because that's, you know what? That catchphrase is part of their identity. They can use that catchphrase as a title for a book. They could use it as, you could make a bumper sticker with the catchphrase, right? So there's just a million different aspects to branding, and it depends on what area you're working in, what you're doing, or who your audience is. But it's any one of those things, intellectual property or not, that helps you define your identity.
So, Julie, when someone does have a catchphrase, is that something that you would recommend that they consider registering as a trademark?
Well, so a trademark is, it protects a word, a phrase, a logo, a catchphrase, or symbol, but it's used to identify goods or services. And so what that does for the owner of the trademark, right, is it helps them brand and create an identity. And what it does is it benefits the consumer because it helps them know the source of those goods or services. So there are catchphrases that absolutely, I think, should be trademarked and should be used appropriately. When you file a trademark, you have to choose your international class or classes. So if it was motivational speaking services, that would be a different international class than if you were creating, I'm going to say clothing, a clothing brand that the clothing brand uses your catchphrase. So you can have a trademark in multiple international classes, and so they are appropriate. A catchphrase sometimes is also called a tagline, right? Because it identifies goods or services. Yeah. It can be with or without logo when you use it in print. So, yep, trademarks can certainly have, I want to say, like fingers that come out and go into other areas, and then you start using your catchphrase in other areas.
Yeah. Julie, let me ask you about, because you mentioned the logo. When should they use it? If you have a registered trademark, what's the proper symbol? Is it R? Is it TM? What's used?
Okay, so there's really two different types of trademark rights. You can have common law rights, which means when you use it in a certain geographical area, and you put a little TM next to it, you're putting everyone notice that is your trademark. If you file a federal registration with the United States Patent and Trademark Office, and it goes all the way through as the application, and you get a registration, then you have the right to use that in every state in the United States. You can also file internationally. You could file in Canada and the UK and be able to use your trademark there, but they're very individual, and it's country by country. Mm-hmm. And so when you have a registered trademark with the Patent and Trademark Office in the United States, you can change from using a TM to a little R with a circle around it. And that means that it's registered.
Okay, so the TM, going back to, I think you said it's a regional thing, so it's just kind of telling everyone this is not without
it's geographical. Yeah, you're putting everyone on notice. So here's the thing: in the past, let's say, few years, we've become very global. So when you use a trademark on your website and you have a TM on it while you're registering it, let's pretend, the geographical area all of a sudden becomes very broad, doesn't it? It's even outside the U.S., but you could assume if you were very popular and had a website that somebody from each of the 50 states is on your website. So geographic is the old-fashioned definition, but that's how we think of it. So if I was using a trademark with a little TM on it, not on the website, but let's say at my business in downtown Denver, if someone registered a trademark that was substantially similar, I would still maintain my rights in downtown Denver. From a geographical standpoint, I could still use it. One of the most famous examples was McDonald's, the hamburgers, the big company, trademarked McDonald's. And there was a big lawsuit many, many, many years ago against a family named McDonald's who had a burger stand someplace in the Midwest. I can't remember where it is now. I haven't read that case since probably law school.
I remember that. Yeah.
So
okay.
they couldn't keep that family from having a hamburger joint called McDonald's because geographically they had been using it there. They used it as a trademark. They identified it as a trademark. They had these common law rights that they could use. But because McDonald's filed a federal registration for their trademark, McDonald's could use it in all 50 states. Right, and they couldn't prevent that company from using it in where they had already been using it.
So everyone got to keep going. Basically, that's what you're saying.
Yeah. So they didn't get a nasty gram they did get a nasty gram, but they didn't get shut down. They didn't have to change the name of their restaurant. They had common law rights in the name, the trademark name they were using.
Well, and that's the bottom line. So we've got that.
Right.
So yeah, trademark. So the regional is that if you haven't filed, let me get this right. You can go ahead and use the TM even if you haven't formally filed with the U.S. Patent and Trademark Office. While it's pending in the Patent and Trademark Office, continue to use the TM. And then once it's registered, you change that to an R with a circle around it. Got it. So, like for me, I filed for trademarks for a couple of things recently, and so I should probably make with our logo add the TM on it just to shout out to everyone saying hands off, leave me alone. This is pending. Is that correct?
Puts everyone on notice. It doesn't even have to be pending. It just puts everyone on notice that you believe that you have common law rights as a trademark for that, whatever you put the TM next to.
So that's important for everyone to understand. If you do have a special tagline or a phrase that is really connected to you, or any other, even maybe you
or a logo,
a special logo or any imagery on that that you want to start using besides. I mean, we used to use copyright on that, but maybe we need to put up just TM to let them know.
So, it's so funny because when you say that, I think that many, many people confuse copyright and trademark. Because a copyright is actually, it's an original work, right, that's been fixed in a tangible medium. So if you had a logo and you could use them in combination is where I'm headed with this. If you had a logo and you used it on, for example, an advertisement, okay, that logo is protected by a trademark, theoretically. That advertisement, and let's say it's a tear sheet, you're advertising your cruise for authors, and there's a big tear sheet and it has all the information, that's copyrighted. When you created that tear sheet, that the literal expression in that tear sheet is protected by copyright. And then down at the bottom, you would put a little C with the year and the book shepherd or whoever was advertising it, right? But you would still keep your little R next to your registered trademark. So they would be used in conjunction to brand you and to advertise and to, they complement each other. So they don't have to be used separately.
All right. Now, I have another question on this, the use of the marks themselves, that I have often told, and I could be totally wrong on this, but I have usually told authors that if you're going to throw out, whether it's your logo, or a word or a phrase, since you mentioned McDonald's, and McDonald's is a registered trademark, that when you use it the first time, that it would be appropriate to go ahead and show it's a registered trademark. But if you keep talking about McDonald's or your name or whatever, you don't need to further on. You've already identified it as that in writing.
Yes, that's correct. Yep, that's correct. And I think you and I discussed it one time too. I think that you said, well, should you not identify? Should you not use the name of a company in your book? And you know what? You're not using it to advertise or to brand against them. When you use the name of McDonald's in your book because it's a murder mystery and the murder happened in the bathroom at McDonald's, you don't have to say the murder happened in the bathroom of the hamburger joint with the 2 yellow arches. You can say McDonald's. That isn't going to be a problem.
Okay. And so, and that's been what I've always done. I've always sold the trademark initially, and then otherwise it becomes an eyesore when you keep seeing the same.
That's right. And then it ruins the flow of the readership, right? Well, it ruins your reading because you keep seeing this crazy. It doesn't look like it fits in there. Absolutely.
Okay. So we have that. I'm happy with that. You know, that just I've told them right. Makes me. So I got myself covered here, which is good. All right. So everyone, what you need to really think about is that when you're writing, if you're using proper names or any entities that do have a formal federal trademark with it, go ahead and put the little R. If it's filed and all those things, but put the R, you can find that out very simply. Then you don't have to keep repeating it. It's a done.
That's right. When people are crying, you can put in there that it was a tissue they used, or you could use the word Kleenex. You know what? That you're not harming, you're not diluting their trademark. And that's what companies look for. And it is pretty easy to go to the trademarks database and look those things up and find out if they're protected. Sometimes, you know, if you want to use something, I can't even think of anything right now, you do need to get permissions for certain things. But
check it out.
In general, you're absolutely right.
All right. Let's come back to this. We're with Julie Bernard. We're talking intellectual property, which is critical for y'all to understand. It's AuthorU, your guide to book publishing.
This is your guide to book publishing. Everything you want to know but didn't know what to ask. With your host, Dr. Judith Briles. And we'll be right back with more great information right after these.
Want to publish like a pro today? Well, then take a look at Ingramspark, the only publishing platform that offers print and ebook services through a single source. Upload, edit, and manage titles all in one place. Take more control of printing costs with print on demand, and reach even more readers through one of the world's most extensive distribution networks. Built by independent publishers for independent publishers, Ingramspark has everything you need to maximize your book's potential: color printing, ebook distribution, print on demand, global reach, and more. Start publishing with Ingramspark today and see just how far your titles will go tomorrow. That's Ingramspark.com.
Many of us have dreamed of writing a book.
Some of us even have.
Then the hard work starts.
You'll need an editor.
Who will design the cover or typeset the pages?
Who will format the ebook?
If you're a business owner, consultant, or coach with a serious message and expertise to share, the team of experts at 1106 Design can guide you through the maze.
They've helped more than 1,000 authors create top-quality books and avoid the not-so-reputable self-publishing companies.
Learn more at 1106design.com.
Then call Michelle at 602-866-3226. 1106 Design.
When Ned Thompson and Harry Shore started Thompson Shore in 1972, they believed employees with great character would make up the best company. They were right. They hired people who were not only experts in bookmaking, but who were obsessed with quality and delivering exceptional customer service. Almost 40 years later, Thompson Shore remains a 100% employee-owned company. Ned and Harry knew that successful customer projects are a direct result of empowered employees. We specialize in all books for large and small publishers. Creating beautiful and well-made books, we're dedicated to pleasing our customers by making the experience a good one from start to finish. The personal touch we have with our customers allows us to be innovative in solving their most difficult challenges. Our platform also ensures that we can remain flexible to meet our customers' unique needs and expectations. Our marketing kit can create buzz for your title, enhancing the promotion of your book during infancy. When you need to test the market to gauge your future sales, we can provide digitally printed books that will transition seamlessly into a larger offset run. From ebook to hard copy to delivery, our skillful customer service teams are at the ready to answer your most pressing question. At Thompson Shore, we know that making the highest quality books requires more than just best technologies. It requires superior customer service, professionalism to the trade, and commitment to environmental and social values. With these standards of excellence in place, you can be sure that we will always help you put your best book forward.
Welcome back to your guide to book publishing. Everything you want to know but didn't know what to ask. Coming up, you'll hear more about statistics, scenarios, and strategies on what to do now to get you published. So let's get back to the show. And here again is your host, Dr. Judith Briles.
You know, one of the things, Julie, I wanted to talk about, and for all of you who are just tuning in, we're talking about intellectual property, we're talking about business rights, we're talking about really protecting your assets, and your book is an asset, but so it's all these other amazing ideas you have, or any spin-offs that come, and even those cups you might be printing and selling. I mean, they all become assets to the game. What happens, Julie, if you get involved with somebody, you bring someone in, not whether they're a business partner or maybe it's a publishing service provider, and it goes bad? It goes bad. So,
well, depending upon who the individuals are going to depend which bad road you go down. My position and what I talk to people about a lot is you might want to have a pre-nup. If you're going to be in business, whether it's writing a single book, writing a series, or creating those 10 million widgets and selling them, you know what? Figure out ahead of time what the terms of the deal are if you're working with others. Figure out if you're an author and you need an illustrator or you need someone to create your book cover. You know what? Who's going to own that copyrighted material? If you wait until after an illustrator has drawn you pictures and say, oh, yeah, I want you to assign this to me, then they may say, oh, no, I never assign my artwork because I want to use it for other things. You know, you can run into problems. And I have had clients who have had to hire a new illustrator and start all over because the illustrator just didn't want to assign it and they didn't want to use artwork that could be used in other books by the same illustrator. So I'd like to say that one of the number one things is to take a look at your ownership of IP, right? Figure out who the author or owner is, or figure out if it's a work for hire, or if someone is your employee. And I will tell you, there's a work for hire is decided by a state law sometimes. So, for example, in California, state law says that a work for hire, if you hire an individual, they're considered an employee. So you might already own what they're doing, but you also have to pay taxes and do withholdings when you pay them. That's a problem. So you might want to, in the state of California, hire someone, even an individual who's a corporation who does illustrations, and have them assign all of the rights to you. So now you've covered all your bases. You don't have an employee, and ahead of time, you've created a contract, so it's an enforceable contract in the state of California that says they're going to assign their rights to you, and here's the assignment, sign this, and so then you own the illustrations.
Mm-hmm. Well, and, I mean, I can tell you right now, I've got one of my clients is doing a kind of like the comic book, you know, for kids on that. Mm-hmm. And she really had to step up her fees to make sure that it's assigned to her.
Right.
But I have to, I'm going to tell you, Julie, when I look at a lot of these and we can kiss on the whole superhero thing, but that format, you know where I'm going to go here.
Let's not.
On those action, that action figure type of thing, that they all start looking pretty similar to me. These artists all have big similarity.
I think that they do to me too, but I think to individuals who are in that area, they don't. They all have these individual, almost trademark genre of art, right? Mm-hmm. So, but the reality is it doesn't matter whether the artist is drawing on a comic book for you because you're writing the words, whether it's a kid's book.
Children's books are huge.
And they're drawing princesses because you know what? Princesses a lot of times look the same to you too. And so I just truly believe that you should, for any relationship, personal and business, negotiate the terms and figure out what the boundaries are, set reasonable boundaries, negotiate them, get it in writing, get all the parties to sign, because you could end up, let's pretend you didn't do that, and you have to negotiate to get your illustrations that you absolutely have to have. You could end up being joint owners of something, right? You could be considered collaborators in the right scenario. Then you both have non-exclusive rights to use the copyrighted material for whatever you want. And that can defeat the whole purpose from a commercial standpoint of having unique illustrations or a unique copyrighted work.
All right, so talk about collaboration a little bit. And that, because we have people who bring in, although I would be glad to sign it over when I'm working with clients who are doing massive rewrites, especially in heavy content development, that's the author's work. That becomes their work. I get paid for fixing things and making.
So that's a work for hire. You're hired to do something for them, and that should be part of your contract with the people who are hiring you, if that's how you feel and you guys have negotiated that term. Mm-hmm. Well, but there are times when you have multiple authors and they're considered collaborators. So if I wrote 2 pages out of a book and you wrote the other 10,000 pages, which is a really long book, we would still both be collaborators and have equal non-exclusive rights to the copyrighted work if that's the relationship we have. We're joint owners, right, and collaborators. Mm-hmm. So sometimes that can create issues too, because what if I was a little snarky and said, oh, you know what I'm going to do? I'm going to use my rights in this book and the branding, and I'm going to use it over here. I'm going to do whatever I want. I don't need your permission because we both have equal right. We have joint rights. Now, under copyright law, different from patents, where the same thing happens when you have joint owners. If you have joint owners and they're using the copyrights individually, you do have to do an accounting to all the rest of the copyright owners. So there's a little bit more that gets tagged on there. But whether you're going to be a joint owner, collaborator, a work for hire, an employee, those things should, at the outset, when you say to yourself, I'm going to write a book, and you know what, I'm going to hire Judith to help me write that book and get it to market, that should be one of the first things you do, is set out the terms of the relationship with the author, between the author and the illustrator, the author and Judith, the author and the person who's going to draw or create the art for the front of the book, all of those things. And I say, look at them up front, figure out what the terms are, decide what the relationship is, negotiate the terms that you need to have to be comfortable, and as soon as anything is fixed in a tangible medium, have the illustrator instantly sign over the copyright by preparing the assignments that was in the contract. The contract says you're going to give me an assignment, so I own them, right? So, and that's what you're paying the author for. Now, there are, illustrator. There are illustrators who won't do that. And if you discuss it up front, you'll say, well, that's okay with me. I really need to have you. You're famous. Or you do the art that I just have to have. I love it. Or you find a different illustrator who's willing to work with the terms that feel comfortable to the author.
Mm-hmm. So is this something, an assignment form, is that you have them sign that that they agree to do that, and then is there another form that they would confirm after everything's done and these are the things that were turned over?
Well, you could make that part of the contract, that the final step to complete the contract is we're going to do an itemized schedule that we attach to the contract, and that means the contract is complete. But it's not necessary. I've done it both ways. In general, what my peers and I like to write into intellectual property contracts is that I agree to assign, fill in the blank, whatever it is, and I hereby assign concurrently my rights with this contract, and then the assignment document actually identifies that I created 3 pictures, they're pictures of whatever, and I hereby assign them to Judith, all the rights that are attached to them, and she now owns them, and I have been compensated for that. That would be the plain language of, what we would call and it can be part of a bigger contract. It doesn't have to be a standalone contract. It could just be an assignment article in a bigger contract, right?
Yeah. I'm just really, I'm feeling concerned really a lot of the children's books that have all these illustrations and they reach out and they pay a lot of money. Boy, they put a lot of money out. And I don't know how protected they are, but they really need to be tuned into that. I mean, and those
that's part of the preemptively thinking about this, that instead of thinking about it as a book with illustrations, if you think about that book or your authorship as a business, then you start protecting your assets. You would never go to a bank, deposit your money there if you don't know what the terms of your bank account are, right? Exactly. You would never just hand somebody over your money. And so it's the same idea. Think about it ahead of time. Discuss what the terms are. Oh, I don't like your credit card terms. I'm going to go to a different bank.
And that's what we do. And that's exactly what we do. So it's really, this is overall protection for those of you. We're going to take our final break here. But if those of you who are going out to places like Fiverr and all those and whipping up these little illustrations, don't think you're going to own them. They're doing these, there's a reason why they're $5. They're going out every which way. So,
if you read the terms on some of those websites, the terms tell you that you're disclaiming all ownership. When you participate, you agree to all their terms automatically by working on that website.
And with that, we're going to take our final break. It's AuthorU, your guide to book publishing.
This is your guide to book publishing. Everything you want to know but didn't know what to ask. With your host, Dr. Judith Briles. And we'll be right back with more great information right after these.
The book shepherding concept is simple. The publishing world is changing, and so must you. You need an experienced shepherd and a guide to partner with you as you create, strategize, develop, publish, and achieve your publishing goals. You can't do it alone without paying the price. You can spend your money creating a book that turns out to be so-so, or you can create a book that looks and feels classy, builds your brand, and is a financial success, a bestseller. It's your choice. You choose. You need the book shepherd. Publishing is riddled with obstacles, sometimes nightmares for the author. You don't need problems. You want solutions. Dr. Judith Briles will shepherd you through the maze and the chaos. At times, she's had to step in and rescue a book that has been sabotaged by a publisher or by a publishing service provider or sometimes even the author themselves. Judith Briles is the book shepherd. If you want to create a book with no regrets, give her a call today. 303-885-2207. That's 303-885-2207. Or email her at judith@briles.com. By the way, Briles is spelled B-R-I-L-E-S. Follow Judith on Twitter at MyBookShepherd and on Facebook at The Book Shepherd.
One of the most important decisions you will ever make is your choice for printing your book. You are choosing a company which will be responsible for guiding you through the process and printing your book at a level of quality and detail that embraces your personal and creative needs. You want to choose a company that when your book finally arrives, you are delighted and ready to move on to the next level, and one that is customer focused. Choose King Printing Company and Addy Books to be that company that brings you to the next level. Go to kingprinting.com or call 978-458-2345 and ask for Tom Campbell.
At Total Printing Systems, customer service is our priority. We are located in Southern Illinois. Our employees have an average of 18 years experience and know that customer relationships are important to our continued success. We have been a short-run book printer for nearly 40 years and always stay at the forefront of technology. Our niche is from 1 to 5,000 copies. Today, we offer digital, black and white, and 4-color high-speed inkjet printing, a cost-effective way to introduce color into your short-run titles. We, of course, offer traditional offset printing as well. Bindery is done in-house, from adhesive case binding to PUR perfect binding to mechanical binding of all types, including side sewing. We provide warehousing, kitting, distribution, inventory management, a new print-on-demand facility, streaming browser-based ebooks, and bookstore. Call us at 1-800-465-5200 for a quote on your next book project. You can also visit our website at www.tps1.com.
Welcome back to your guide to book publishing. Everything you want to know but didn't know what to ask. If you want to write and publish a book, if you want to be successful as an author, your guide to book publishing, everything you want to know but didn't know what to ask, is for you. Stay tuned and you'll hear about statistics, scenarios, and strategies on what to do now to get you published. So let's get back to the show. And here again is your host, Dr. Judith Briles.
All right, so this show is about covering your tush. Put it bluntly. So you don't get into trouble. And I want you all to know that even smarty pants also get in trouble. I mean, I brought in partners, thinking it's all going to be wonderful and and it all went to hell in a handbasket. And usually those things happen pretty quickly, but it became very costly to unravel it. So what we're talking about is, and Julie's used the phrase, Julie Bernard, who is one of my favorite intellectual property attorneys, is using the phrase a prenuptial. Before you get into anything that could have a ramification to you. And so you need to look at this, any repercussions. You need to look at these kind of things because before you jump in. Julie, I would love to have you make some comments about, I get calls often about people about going into anthologies where someone is collecting a lot of money, usually to go in, write a chapter, and I'm going to go out and promote it and doing this. And usually I will say, don't do it. But maybe sometimes the beginning, a wannabe.
Well, what if you wrote a chapter in a textbook? But you know what? It's a similar idea. So yes. A lot of times when someone's putting together that, it's a compilation is what it is, right? They'll have each individual author will assign their rights to the umbrella corporation, the editor, unless you have that all tied up ahead of time, everyone who contributed is now a collaborator, and they would each have the same rights, wouldn't they? So you have to, that's again, when I say prenup, I'm not trying to be funny, but if you assume going into any, even the best business relationship, 6 months down the road, there's going to be a disagreement about something. It's how big of a disagreement it's going to be. Can you have a cup of coffee and figure it out, or do you need to arm wrestle, right? And so or more. I'm just saying, think about those things ahead of time. Figure out what, what you could do to just preemptively say, this is how we're going to fix our disagreements. There's always disagreements. Everyone has disagreements. And the same is true in businesses. And so, you know what? You can call it whatever you want. But basically, I say negotiate the terms of your relationship before there's any misunderstanding, because I think, and especially, you know, it happens between, you could say, a physician's office. The physicians all need to decide what their partnership looks like. Lawyers, the same thing goes for authors. When there's several authors working on books, and it happens all the time, you need to know what the terms are ahead of time. When you say anthology, I instantly start thinking of there's 5 people, they each wrote a chapter, and somebody wrote the first chapter and the last chapter, and there's 4 people in between who wrote chapters. And usually...
Yeah, the reason I'm careful about them, because especially for my nonfiction, well, both authors, is that you're a developing author. I don't care what stage you're in your writing, you're always developing other stuff, and that work that you turned into that anthology may very well be the genesis of a major work that you're working on, but because you've given your rights away. You know, what do we do, Julie?
Well, you think about it ahead of time and you figure out what you're willing to do. You know, there are some authors who never ever author their own book, and they aren't interested in that. They aren't interested in the marketing. They aren't writing a fiction book that's going to be marketed with their name on it. They only write parts of other people's books. And you know what? There's nothing wrong with that, and they don't mind. They don't mind having their work as part of others' work, and they give up the copyrights, and those copyrights are owned by another entity, and it could be a corporation or it could be another author, right? Mm-hmm. So, you know what? That's why I say you have to think these things through ahead of time, because everyone has a different threshold of what's acceptable and what's not. You know, in most contracts, I say put together a term sheet. What are your terms? What are you willing to do and not do? It's just the negotiation of a relationship.
Always that way. It is a relationship, but the bottom line is know what you're getting into before you get into it. Right. And figure out if it's... And
do it with your eyes open.
Yeah, and if it doesn't feel right, you need to sit down, and the sooner you can unscramble it, the better. That's been my experience. I think too often we stay in things, and it really gets worse. All right, let's talk about, we just have a couple of minutes left, but what about the application filings for the copyright, timing for filing? What's the cost of all of that?
Online, last time I looked, it was $55 for a copyright application. It's online at the U.S. Copyright Office. Mm-hmm. And the timing of it can be, you even have to file it, right? Your copyrights come into existence when the work is created. However, if you want to enforce your copyright, you theoretically would want to file within, because theoretically you want to enforce it. You would want to file your application with 3 months of the first publication. And that's because that gives you statutory damages when you do have to enforce it in a court. Now, if you don't do that, that's okay. You still would have to file a copyright application before you could actually enforce it. So file suit against someone. But it isn't required.
Yeah.
Right. But what I always suggest to people is for anywhere from $35 to $90, it is the cheapest insurance policy you're ever going to get. You're ensuring that should you need to enforce your copyrights or send a letter to someone that says, hey, this is my copyrighted work and it's on record with the U.S. Copyright Office, everything's all done. You've already got your ducks in a row. It's the same thing as when I say negotiate your relationship. Think about, when you do cost-benefit analysis, the cost is, let's say, $55 for the application and some of your time or an attorney's time versus, you know what, you have to go after the fact and figure out how to enforce and or clean up a mess. So, I always suggest people consider it, but it isn't necessary unless you want to either have the insurance policy or to enforce your copyrights.
But I have had authors working with authors that immediately, as soon as they have their first draft done, they will file it, and then every time there's a renew, they keep refiling and refiling, and I don't think that's really necessary.
Well, literally, it could be necessary because every time you change something, that's the actual embodiment that's been fixed, right? However, nobody's going to copy each one of those permutations. Somebody's going to copy the final book that you publish, right? That's the number one thing that you want to file a copyright application on. I know that people who are, I'm going to say fastidious, they might have a piece of artwork, something that's on a canvas, and every time they change the color scheme or every time they change the perspective, they might file a copyright application. Is it necessary? Not. But does it make them feel better because that's their personality, or that makes them feel like they're taking care of business? Again, relatively inexpensive insurance. But every time you write, if you have a 10-chapter book and you go back and rewrite 3 pages in chapter 2, until you get to the final draft or the galleys for publication, in my opinion, you probably don't need to file it because nobody's going to infringe your rights from the drafts, right?
Yeah, that's where I come from. I can, if you want to do the first, but the fine tuning and the editing, and then that when we have the completed book is when we file the official with it.
Well, and that's one of the things that you need to look at a contract when someone's helping you, or you're doing it yourself, or you're working with a publisher. Who's going to file the copyright, and what timing is the copyright get? You know what? Unless it's spelled out, it's the author's responsibility to file the copyright, not the publisher's.
It is
theoretically.
Yeah,
right?
theoretically, but
we have put that in the contract.
We have one more minute, but here's what I want to say to everyone on the copyright. Make sure you're clear who's owning this copyright. If you're working with another publisher, I don't want you to put it in the publisher's name. It is your work. And so many times, Julie, I see that get screwed up.
Yeah.
All of a sudden, the author's going, wait a sec, it's not mine, and it should be. So with that, thank you, Julie Bernard. How do people get a hold of you?
Well, they could call me. They can go to our website and send me an email, and I'll respond. They can get a hold of me through you. Website is bernardiplaw.com.
All right, bernardiplaw.com, and that's how we'll wrap it up. Okay, so go to the website, bernardip.law.com. We all need help. All of us need help. Right? And we'll be with you next week. Happy writing, happy publishing, and it's AuthorU, your guide to book publishing.
Thank you for being a part of Your Guide to Book Publishing. Everything you want to know but didn't know what to ask. With your host, Dr. Judith Briles. Each week,